Should you set up a revocable living trust? In this video, I'm going to share with you what a living trust is, how it works, and its benefits. After watching this video, you'll know if a revocable living trust is right or wrong for you. And you'll learn how to save your family thousands of dollars in legal fees. Hi, I'm Pamela Maass Garrett. I'm a lawyer and the founder of Law Mother, and this channel helps parents with money and legal tips to provide a lasting legacy. Let's dive into Living Trusts 101. In order to understand a revocable living trust, also known as RLTs or living trusts, you first need to understand what happens to your assets when you die or become incapacitated without a trust. When you die or become incapacitated, one of three things will happen. First, you die without a plan. Second, you die with a will. Third, you die with a trust and a pour-over will. First, if you have no plan, your assets will go through probate. Probate court is a process where a judge, who is a stranger to you, decides what happens to your assets and minor children if you have them. The judge will follow the laws of the state you live in at the time of your death, or where you own real estate. If you own property in multiple states, listen up, because each state will have its own probate case. For example, if you own property in both Florida and Colorado and you die without a plan, your family will have to go through probate court in both states. Probate is often described as a lawsuit against yourself for the benefit of your creditors. Sounds bad, right? It is. The disadvantages of probate are the cost, the time involved, the government in control, it's public, and it's costly. AARP found that on average, 5 to 10% of an estate is eaten up by probate costs, and smaller estates suffer just as much as larger ones. Probate is also time-consuming. Your assets are frozen and your loved ones are at the mercy of the court's timeline. On average, probate can take 9 months to 2 years, but there are horror stories of it lasting 3 to 6 years. The people who go through this complain of dealing with probate and lawyers feeling like a full-time job. Additionally, probate is public, meaning it becomes public record who inherits what, which can make your loved ones vulnerable to scammers and predators. The second option is dying with a will, but a will guarantees probate. We just went over all the disadvantages of probate. So why are lawyers still recommending wills? I wonder who will benefit from the court case. That's right, lawyers. That same AARP study mentioned that lawyers should be required to tell clients how much they will charge for probate when they recommend a will. Wills are often loss leaders for law firms, which end up making more money on probate. Be cautious if a lawyer recommends a will. Ask what they charge for probate. Now, there are many good lawyers who recommend wills with the best intentions, but some just don't know any better because that's what they were taught to do. Or estate planning might not be their specialty. Just like you go to a specialist for heart surgery, you want to work with a lawyer who focuses on estate planning. So what about small estates? Well, it depends. Some states have streamlined processes if you have less than a certain amount of assets, such as $75,000. In these cases, a will may be okay. But remember, avoiding probate isn't the only benefit of a trust. With a trust, you have more options to protect your assets for your children. The third option is dying with a living trust and a pour-over will. That same AARP study concluded that living trusts are better than wills. And in my experience as a lawyer for 14 years, I agree. If a living trust is drafted correctly and funded properly, meaning your assets are placed in the trust, it will avoid probate. Additionally, you can include asset protection language in a trust to create a lasting legacy. Now, you'll want to stick around to the end of this video because I'm going to explain more about asset protection and how it can make a huge difference for your family. But first, let's talk about how a trust works. A revocable living trust is a legal document that you set up during your life, and you are in control. It's revocable, meaning you can change it and take things in and out of it throughout your life. You can also change the terms, and if you're married, you can create a joint trust, or you can keep separate trusts. You may hear the term like living trust or RLT, and these refer to the same thing. Funding your trust means transferring your assets into the trust. For example, titling your primary residence into the trust. A pour-over will is often combined with a trust. It's created as a safety measure, stating that any assets outside of your trust at the time of your death will be placed into your trust. While we hope it never has to be used, it's there for protection. However, we don't want to rely on a pour-over will because those assets would still have to go through probate. There are some myths that keep people from setting up trusts. The first myth is that trusts are only for multimillionaires. That's simply not true. There's no minimum wealth requirement for a trust. I've created a trust for a client who worked at Walmart and for clients who own multi-million-dollar businesses. It's not about how much you have. It's about the experience you want your loved ones to go through when you pass away. It's also about control. Do you want to be in control, or do you want the government to take charge? Another myth is that trusts are more expensive than wills. AARP found that this wasn't the case. Sometimes you need to spend money to save money. Trusts may cost more upfront, but they save money in the long run for your family. It's about paying a little more now to make things easier and less costly for your loved ones in the future. A third myth is that you don't need a trust if your beneficiaries are adults. You can just use transfer on death designations. But transfer on death designations aren't triggered if you become incapacitated because you're not dead. So they don't provide any incapacity protection. And so your loved ones will still have to go through probate if you become incapacitated. Additionally, transfer on death designations don't provide asset protection or help create a lasting legacy. Now let's dive into the asset protection benefits of a trust and how you can create a lasting legacy for your spouse and children. First, a trust can help minimize or eliminate estate taxes for your spouse when the first of you passes away. The federal estate tax rate is currently at 40% if you are over the threshold. And that threshold has changed over time. Initially, it was 1 to 2 million, and more recently it's at 13 million, but it's set to go down to 6 million in 2026. Estate taxes are a moving target, so if you want to minimize or avoid them, you need trust-based estate planning. And some states even have their own state estate taxes, so it's important to work with a lawyer in your state to minimize those taxes. A trust can also protect your surviving spouse from future divorces and creditors. As for your children, a revocable living trust can flow into a lifetime asset protection trust for them. This provides protection from future divorces, creditors, and lawsuits. For example, if your child inherits $1 million and later gets divorced or sued, their inheritance will be protected by the trust. A trust can also provide guidance on how your children will use the money, helping them make smarter financial decisions. You can spread out their distributions over different ages and stages, or even appoint a co-trustee to guide them. These trusts can also be set as dynasty trusts, carrying on for generations and generations. If you have a special needs beneficiary, you can also include a special needs trust. If you like this video, your next step is to watch my video on the 5 living trust mistakes and how to avoid them. I'll link it here.